We're all here today actually on the impulse of the National Security Archive. And we're here to talk about kind of beginning with the Araguaia case in Brazil and the Inter-American Court decision to talk about a broader set of issues that kind of flow from that about access to records and human rights and justice issues in Latin America, broadly speaking. And I think the way we like to structure the discussion is to ask Michael Camilleri from the Office of the Special Rapporteur for Freedom of Expression at the Inter-American Commission to tell us a little bit about the case itself and the decision. We're going to follow that. We have the good fortune to have with us Paulo Sotero, the director of the Brazil Institute at the Woodrow Wilson Center, to talk about reactions to the case and more broadly the issues in Brazil itself. Jo Marie Burt from George Mason University is going to talk about human rights issues and access to information in relation to human rights issues in Peru. And finally, Kate Doyle from the National Security Archive will talk generally about the implications of the decision and access to records in human rights cases, and I think talk a little bit about a conference that was held in September,
Yeah.
that looked at this issue kind of regionally. So I think with that, I'll just turn it over to each of our speakers. I think we'll try and give everybody about 10 minutes and then have time for questions. More?
Yeah,
okay.
2 hours.
And we'll have time for questions and discussion. I should also say
Very thick.
by way of commercial here, there's Jo Marie reminded me actually probably the National Security Archive, the Woodrow Wilson Center, and WOLA and George Mason all have various publications related to the issue, all of the issues here on the table. WOLA has one on human rights tribunals in Latin America. It's from a conference done 2008. There's a report on the Fujimori case that George Mason did. I have no doubt everyone has other material they can speak to. So with that, we'll let Michael start.
Thanks, Geoff. As many of you know, I worked next door to Thale for many years, including on the Araguaia case, so I feel like this is I'm going to be back in the neighborhood. It's good to be here. I'm going to try to briefly summarize about 10 years of inter-American jurisprudence in order to not only talk about the Araguaia case, but also sort of put it in context. What led to it, the decision itself, and what comes next, what the existing sort of challenges are, what the opportunities for further development are, and what we're seeing in the American system and perhaps in the region. I'm sure those are issues that my colleagues will touch on as well. I assume the Inter-American Commission and Court need no introduction in this room, so I'm going to skip that part completely and just say that knowing what we know about what's happened in Latin America in the last 20 or 30 years, it should be no surprise that issues of atrocities committed by security forces and armed forces frequently come before the court. Frequently in those cases, the security services in question are not too keen on the information making into the public realm or being provided to those who would seek to investigate those crimes. So it's really no surprise that issues of access to information about human rights violations should come before the Inter-American System on Human Rights. The first case in which we see this is a case that many of you probably are familiar with. It's the Mack case from Guatemala. Myrna Mack, of course, was an anthropologist who was killed by the Guatemalan intelligence services in the early 1980s. And in that case, the prosecutors in the case actually asked for information from the intelligence services, which was denied on the basis of this national security exception. And what the Inter-American Court said when it looked at this was that under no circumstances can a national security exception to the right to access information be a basis for denying information to those who would investigate human rights violations. Now, it did this under the rubric of access to justice and not access to information. So this was exclusively a sort of right to a due process right analysis. But it begins to struggle with these issues of what happens with this information that's in state archives that would help us solve these crimes. Then that's 2003. Then we jump to 2006, and there's a landmark access to information case. It doesn't have to do with grave human rights violations. It's a case involving access to information about a logging project in Chile. But for the first time, the court says there is under the American Convention on Human Rights, a right to access to information. That applies to all citizens, and so this right of access to public information is something that's contemplated in the American Convention on Human Rights. Fast forward to 2009, the Rosendo Radillo case. Rosendo Radillo, as many of you probably know, was a social activist, a mayor in Mexico in the 1970s who was disappeared by the military. And one of the things that the court looked at in that case was the fact that the victims of the family members of the victim of Rosendo Radillo were being denied access to the investigation file. And here you see the court begin to sort of pull together the access to information piece and the access to justice piece, what it said in Reyes in this Chile case, and what it had said in the Mack case. It keeps it, it continues to limit it to the sphere of criminal prosecution, so the criminal investigation. So it's talking about access to the specific information in the investigation file, and it's still doing it under this access to justice rubric and not moving it into the sort of access to information sphere. So that's sort of the background. Those three cases sort of form the background to the Araguaia case, which some of you are probably familiar with. What Araguaia did is finally bring these two strands of jurisprudence together. So what the court now, Araguaia, for those who aren't familiar with the facts, the Guerrilla de Araguaia was a dissident movement in the 1970s, the members of which were, hundreds of them were disappeared by the military during the dictatorship. In 1982, before the dictatorship had even ended, family members of the victims initiated it wasn't a criminal case, it was a civil case, I guess, or an administrative case, asking for information about the military operations in Araguaia where these people had been disappeared, where their family members had been disappeared. This case starts in 1982, and for the next 18 years, until 2000, the response of the Ministry of Defense was, first of all, to obstruct the process in any way possible, but also to deny that any such information existed. That their stance for 18 years was that all this information had been destroyed. In 2003, there's finally a judicial decision saying that the military had the obligation to turn over the information. That decision they don't even begin to comply with that decision until 2009. So we're talking more than a quarter century after the family members had initially asked for the information. And it turns out, there were thousands of pages of information available. So, this excuse that the military had given for all this time turned out to be pretty far from the truth. So those are sort of the facts of the case. What did the court say about this? Again, the court sort of begins to bring together this access to justice piece and the access to information piece, and finds violations of both rights in the Araguaia case. And it says a number of things that are pretty important. First of all, it repeats what it had first said in the Mack case, which is that information on human rights violations can in no circumstance be denied to investigators, to prosecutors. It cannot be an obstacle to investigating these types of crimes. And it begins to go a bit further in suggesting that actually not only investigators but also victims should have a right to this information. Then it talks about the state's duty to produce the information. So it looks pretty closely at this excuse that the Ministry of Defense had given for so long that the information didn't exist, that the whole, all these judicial proceedings were moot because, there's nothing left to provide in the first place. And it says, the state has an obligation to look for the information and to produce it. It can't just simply say, sorry, can't do it, all the information has been destroyed. And finally, the court emphasizes the procedural guarantees that need to be in place. So there needs to be an adequate procedure for resolving requests for access to information. There need to be time limits on that information. It needs to be supervised by officials who are adequately trained, and there needs to be access to judicial review, which is speedy and effective. So creating a whole series of procedural guarantees around this right to information. So where do we stand after Araguaia? The court clearly has taken a major step forward in terms of defining the specific obligations of states to locate and provide information that may be useful in investigating grave human rights violations. That's significant. It also leaves a few questions sort of unresolved, and we think probably because of the facts of the case. Again, it was relevant in the case that the response was not that the information was classified. For the most part, it was that the information had been destroyed. So what the court said really was in response to that. It had to do with the obligation to find information, to preserve information, to produce information, and not so much looking at under what circumstances can a national security exception be invoked, if any, when investigating human rights violations. So the sort of the agenda for the future in terms of this issue is I think, and I'm sure my colleagues will discuss this, is figuring out, okay, exactly what are the limits on invoking a national security exception in these types of cases. And so I would just mention a couple of things that are, I think, happening right now or likely to happen in the near future. One is a case that Kate knows very well, which is a case called Diario Militar. It's another Guatemala case currently pending before the Inter-American Court of Human Rights. This is a case involving hundreds of forced disappearances committed by the Guatemalan security services in the 1980s, in the early 1980s, that were chillingly documented in a diary of sorts, hence the name Diario Militar, which provides precise information regarding when each of the individuals was captured and when and where they were eventually presumably executed. The victims, again, of the family members of the victims of these crimes asked for information from everybody conceivable, including the erstwhile presidents of Guatemala. This information was never forthcoming. The Truth Commission asked for the information in Guatemala, and it was denied to them on national security grounds, among others. And most recently, prosecutors looking into these disappearances asked for the information. Again, it was denied. It wasn't until the document was leaked in 1999 and made public by the National Security Archive that all this information became public. And it became clear that the armed forces had been denying information that was critical to solving these crimes, either based on this national security so-called exception, or by simply denying the existence of any such information. So this is a case that's factually allows the commission in deciding the case to address some of the issues that were left pending in Araguaia. And the case, again, is now pending for the Inter-American Court and will hopefully provide an avenue to begin to consolidate what was said in Araguaia and expand upon that and resolve some of these pending issues. So just to mention a few of the things that the Commission is arguing before the court in the Diario Militar case. First of all, obviously, again, information on human rights violations can never be applied, it can never be denied to investigative authorities. Second, this right of access extends in all cases to the victims of forced disappearances. The logic behind this is that denying information about the forced disappearance of a family member to a relative of that person is equivalent to torture. That's what the Inter-American Court has said for decades. And so the idea that you would have some sort of exception that would allow you to psychologically torture the family members of victims is sort of absurd. So in all cases, victims of forced disappearance have the right to access this information. Third, there is a limited public right to access such information. Limited in the sense that it's subject to a national security exception, at least in theory. It's not an absolute right to access all this information. However, whenever such an exception is invoked, it must be reviewed by an impartial tribunal. That is, you can't have the military deciding that the national security exception applies to military information. There has to be an impartial tribunal that's deciding on these questions. And the state in these proceedings must prove a real, objective, grave, and current harm to the national defense of the democratic state. That is, there's a pretty high bar to invoking a national security exception when you're talking about information about human rights violations. Fourth, these obligations, these state obligations, are heightened in transitional contexts in a couple of ways. First of all, it's very difficult to imagine that when a country is transitioning from an authoritarian regime to a democratic one, that information about the human rights violations committed by the past authoritarian state would somehow need to be kept secret in order to protect the national security of the current democratic state. Hopefully that's more or less clear. But this comes from a European court precedent out of Slovakia, in which Slovakia had tried to keep secret information about abuses committed by the former communist government. And what the European court said is, this is absurd. Under no reasonable argument is keeping this information secret necessary to protect the present-day national security interests of Slovakia. And what the Commission says in this case is the same, that it's very hard to imagine that present-day national security in Brazil really depends on maintaining the secrecy of human rights violations committed by the military dictatorship 40 years ago. So again, in these transitional contexts, succeeding on a national security exception is extremely difficult. And then the other thing the Commission says and is now arguing before the court is that a lot of the considerations that apply to investigative bodies should apply to truth commissions. So when a state, a country decides to create a non-judicial body to investigate and clarify human rights violations committed in a period of its history, that those extrajudicial bodies should have the same sorts of access that a prosecutor would normally have. And then finally, the Commission sort of follows up on and expands the obligation to produce and preserve information that it had announced, that the court had announced in the Araguaia case. And here it talks about how in Germany, for example, Stasi records that had been shredded and were literally sitting in bags of shredded paper had been meticulously pieced back together in order to preserve the right of access to information of the victims of Stasi crimes. So that's on sort of the inter-American front. That's where we are. We've got a solid basis with Araguaia, and we're trying to sort of build on that with the Diario Militar case, which is likely to go to the court in February of next year. What are we seeing really briefly in the region? I'm sure you will talk about this in greater detail. There's an emerging human rights exception to the national security exception in access to information. This is, I think, we see this clearly in the Araguaia and even more specifically in the Diario Militar case. We also see it in a number of national legislation. So Mexico, Guatemala, Argentina, Uruguay, Peru, and now Brazil that just passed an access to information law. Maybe there are others that El Salvador. I'm trying to make a note of that. Have explicitly put in their access to information laws that the information on human rights violations cannot be denied on national security grounds. Several constitutional Supreme Courts in Colombia, Guatemala, and Argentina have said the same thing. Mexico, just a couple of weeks ago, the Supreme Court for the first time applied this national security exception, again in the Radillo case, to finally provide access to the investigation file to the family members of the victims. So there's this emerging exception. It's not clear exactly what it means. It needs to be tested in administrative proceedings, in court. Hopefully it will be interpreted in an expansive way. There's a whole question about who has to prove that we're in the realm of a human rights violation. Does that have to be proved before the exception can be invoked, or is that something that victims can simply claim? There's issues there that need to be fleshed out, but clearly there's been progress made, and there's I think a pretty interesting agenda for the next few years in terms of continuing to pass these laws and then putting them into practice. So hopefully that's more or less clear as a place to start the discussion, and look forward to questions and comments. Thanks.
Great.